Okay, so I have finished screen recording that entire uninterrupted hearing. It's very long, but it's very well worth listening to for anyone who's at all interested in how the Tenancy Tribunal actually operates. It is There is no way in hell anyone can claim that that is an accessible justice mechanism. That is like that's just like court, and I thought that court at least would. If it's going to behave like court, it would behave like court in the full way, not just to the benefit of one party. But it doesn't, and in fact, what I've discovered of court and criminal court, in fact, is that it appears to take the same sort of route. Although I haven't had a trial yet, and those hearings are the equivalent of trials. That is not accessible, and in the information on the Tenancy Services website, and bear in mind Tenancy Services and the Tenancy Tribunal are not the same entity. It's really weird, but the Tenancy Tribunal, and it's quite hard to get a straight answer from any of the people who should know, because I don't think anyone really does know. I always understood the Tenancy Tribunal to be a sort of a hybrid or the offspring or a joint enterprise between Tenancy Services, which is a department or an agency under MB, Ministry of Business and Innovation and all of that, and courts or Ministry of Justice. And then I hear different things like, well, I've heard something that said, no, they're just granted the right to hold sessions in the courthouse, but that doesn't really make sense to me if they can make orders of tribunal that are enforced by Ministry of Justice. I can't see Ministry of Justice can shrug their shoulders and say we're not responsible for this. The more I live and learn as an adult, and I do a hell of a lot of learning, man, like I really, really, really do. I pay a lot of attention, and as disadvantaged as I am in some ways being an Aspie, I'm advantaged in other ways in that I really can nut things out and get down to the basics. In philosophy it's called simpliciter, when you can't analyse any further. You've reached the foundation. There's nothing further to divide into any other concepts or principles, and I can't see that Ministry of Justice can escape taking responsibility for this, especially I'm not going to belabor that. I think that's quite clear. So this is why Tenancy Services and the Tenancy Tribunal don't appear to have any continuity between them and what goes on. And you'd think that a tribunal, which is clearly, whatever anyone may deny, is clearly part of the courts, clearly part of New Zealand courts. You would think they would be the experts on the law, but actually the Tenancy Services, who hire people, quite possibly people, law students, I don't know, but they're not. I don't think they're sort of legally trained. I think they're trained in that legislation, like I have been trained in legislation when I've worked in government departments, but they're not lawyers, but they are very clear on what what the RTA is and what the Tenancy Tribunal may or may not do. But the Tenancy Tribunal just does whatever the fuck it wants, just like criminal court does. And so what we missed out at the end there, unfortunately, the phone I was recording on had conked out, and so we missed the end bit. But it was still, I can't remember what really was decided. There wasn't a decision made, and Rex had made it clear that he wasn't going to indicate any decisions. But I felt from his manner toward me that he was very amenable to what I was saying. And he got a bit confused there at the end by thinking that I was disputing the amount of rent that the discrepancy between the advertised rent amount and the paid rent amount. He didn't seem to understand. It took him a very long time for the penny to drop. And I thought it had dropped, and then he picked it up again. That I'm not disputing there is a difference, I'm not disputing that I didn't pay $70 a week in rent for that period of time. I'm disputing that those are rent arrears. Rent arrears is rent that is owed. The rent that I wasn't paying was compensation, and he was barking up the wrong tree when he was asking what time period that applied to. There wasn't a time period applied to it. There was an event applied to it, and that's when the oven was fully and completely repaired, completely resolved, as Caroline said in her own words. Now, the fact that they didn't resolve it until just before they managed to boot me out, and they resolved it by replacing the oven, which kind of proves that cleaning it wasn't the remedy. Why would you replace an oven if the cleaning remediated it? That would make it a cosmetic improvement, and that would give me the right to deny access to the landlord if it's not necessary. If the oven cleaning had fixed the problem, then I did not need to let them in to make cosmetic improvements by bringing in a new oven. So no matter what I did, I was damned. And to prove that even further, in his order of tribunal, he said that I did owe those rent arrears because he regarded the fact that I had finally let the cleaner in to clean the oven, even though she had said to me and to the crooks, because I have conversations between them released to me under the Privacy Act, that she made it clear to everybody that cleaning would not repair the rust, but because I had accepted the cleaner to come in, Rex said that meant that I accepted that as a remedy, and therefore any compensation I retained from my rent after that was arrears. Now, you just do not have that much leeway as an adjudicator. I'm sorry, you just don't. And if you do, then stop pretending this is justice. Stop pretending it's justice. Because he's wrong on 2 points. One is that I was forced to receive Vivian, the cleaner. I didn't have a choice about it. I didn't accept it. I was forced. Okay? I did not accept it as a remedy. I said she did a wonderful job, and Dominic et al. Had previously claimed that my praise of Vivian's amazing cleaning work amounted to my approval of her repair of the oven. No, I've been a cleaner. Cleaning is not appliance repair. You can do an amazing job cleaning up an old car, repainting it, I don't know, panel beating it, doing all sorts of things. You can pimp my ride, but if it hasn't got an engine in it, you can't drive it. So you can praise the cosmetic appearance, and that is entirely the purpose of the quiet enjoyment and why landlords can't come in to make cosmetic improvements. All that they had done was make a cosmetic improvement. I still didn't use my oven, and I never did. And so they destroyed their own argument by replacing the oven. Now, they can't have it every which way, but they did have it every which way, and Rex allowed them to have it every which way. And what else Rex had missed in the Tenancy Tribunal is that it is very, very clear in an introductory section under landlord's general responsibilities, I think, and it's about the state of the condition of the property when you move in. All repairs have to be done before the tenant moves in. They may not be done after they move in. Now, they're missing the point that they were going, oh, well, the tenants requested these repairs, and it's like, well, the tenant shouldn't fucking have to. The tenant is disadvantaged, and you've broken the law by renting her a house under false pretences, saying that these things work when they don't. So that's a breach of the law, and I'm owed a lot of money for that. Secondly, even if and also you can't contract out of agreements, and even if I had freely accepted the cleaner to come in, which I didn't, I accepted under extreme duress, having resisted for a very long time, under extreme duress, because I basically had a court order, order of tribunal. I didn't accept it as a remedy at all. But even if I had, the thing is that that doesn't make me legally culpable. You cannot, as a landlord under the RTA, offer a property as is. You can't tell the tenant it's substandard and that's just what it is. You're not allowed to do that. It has to be in good repair, and there's a bit of a margin for making a decision about what good repair is. But a rusted up oven is a very it's well over that threshold. So even if Rex wasn't a very good lawyer or adjudicator, the fact is that the overriding principle of the Tenancy Tribunal is that it's accessible and it's natural justice, and that any deviations from the statutory wording should be in aid of increased fairness, not to find loopholes. So it was just so fucking corrupt, and I'm happy to publish the recording of that, because if anyone, I think something, I don't think you're supposed to record those sessions. I imagine you're not supposed to, and I imagine you're not supposed to publish them, but I published them at the time, and that was getting on for a year ago. When was it? July, it's March. Sort of 8-9 months ago, the offenders and the offending applicants, have complained about everything under the fucking sun, but nobody has dared to complain about my publishing that, because that's opening up a can of whoop-ass for them. And if police want to arrest me, or if someone wants to prosecute me, bring it on. It's self-damning. It is self-damning. And it's criminal, this EC. Tenancy tribunal adjudicators have roughly the same immunities from repercussions that court judges do, but it's only for mistakes or, errors made in good faith. They're even protected from misinterpreting the law if they do it in good faith. How's that for justice? How's that for justice? It's awful. It's awful that you can make an error, and an egregious error of law, but if you've made it in good faith, i.e. you're incompetent, your victim has to wear the costs, even though they're completely innocent, and they're the ones who deserve the justice to be on their side. So the only way that you can get around that is by appealing to the because when you apply for a rehearing, do you know who assesses your application? The original adjudicator. So, as I've said before, it's like asking school children to mark their own homework. You need an independent party, or at least someone else, and I would say that you need a panel for every one of these decisions that includes huge amounts of money and someone's losing their home. These are really, really, really big deals. And you could see all the way through, and he did this to Dominic as well as me, although Dominic was on much shakier ground. But on that particular isolated principle, he did the same thing to Dominic. He's just like, yeah, if you don't like it, you can appeal to the district court. That's not practice law. You can't just like fob people off to the district court if they've proven that you're don't know what the fuck you're talking about. It costs a huge amount of money to take someone to court, and that's not accessible, and that's not justice. I looked into applying, just because I was interested. So it's $200 to apply to the district court to appeal. So it's called an appeal of the tribunal decision, and the district court may decline, and I understand from some sources that they are prone to declining because they are of the belief that, the district court is of the belief that the tenancy tribunal adjudicators do stealing legal work, and they're unlikely to interfere with their decisions. So you could just lose $200 like that. Then after that, if you do get accepted, you're still in, if you're a traumatised victim like I was, you're not in any better position. I still don't have a lawyer, and I'm still traumatised, and I'm still got tech that's falling apart. Like, you could hear my tech was falling apart then. I had paid $600 then, and since then my battery, anyway, whatever, I've gone on and on and on about my tech failure, which is a massive disadvantage in itself, and it's discriminating against someone financially, which is verboten under the Human Rights Act as well. It's $900 for every half day in court, and I think a half day is something like 9:30 to 1. And then if court is anything like tenancy tribunal, they don't have to, you don't necessarily get your full day, half day. They can just end it after an hour if they want to, and I expect it would be judge alone, so you're not necessarily dealing with anyone better than an adjudicator. And the other thing is then if you lose, then you're liable for the other person's legal fees. And so even in the tenancy tribunal, for fuck's sake, I've got to pay some of Dominic's legal fees. So I basically have to pay for the privilege of having been criminally harassed by a bully who happened to have a law degree but doesn't practice law. So I think I managed to make it clear at the end, but at the end, my spirits were reasonably high. I recall, I remember thinking, there's no way these fucking fools are going to get away with their blatant lies. And I feel like Rex was turned because his order was fucking nonsense. His order of tribunal was fucking nonsense. It just repeated the same lies that the applicants had submitted. that I had refuted with logic, with law, and with evidence. And that's when I knew for sure that Harcourts buys tenancy adjudicators, and that's not paranoia, because laws are created and amended and repealed and all kinds of stuff according to precedent, I guess some case law or changing circumstances or all that kind of thing. And it's a bit like warning labels. If it says don't let your kids play with the cord on the blind. And there's different coded words, which I learned in forensic linguistics, and I learned the codes. It's not like it's all secret squirrels, but the codes is like caution, warning, danger. I think those are the three things, and each one of those means something different, and they are different levels of hazard. And the highest level of hazard is this has resulted in death. Now it doesn't say so. It doesn't say that this is a common cause of death. In so many words, but it has to be clear enough that people take it seriously. And as we know, it's not to protect the user or their baby; it's to protect their own asses, because they say, well, look, if you wanna take a torts claim in America, you can sue over fucking everything. It's like, well, sorry, we did warn you, don't let your baby play with this, and we made it very clear, and we put it in big wording and all that kind of stuff. So, that's how they, that's the purpose. And protecting their own asses is fine. Lawsuits are expensive. Dumbasses are multitudinous. But the reason I talk about this quasi-judicial corruption is because there is a whole fucking part of, not just a section, a whole part of the Crimes Act devoted to judicial and other officials and corruption, and so those different sections apply to the officials themselves, and they also apply to those who are corrupting the officials. And corruption in this case does mean bribery, or other I think pecuniary advantages. So anything that gives an advantage. So I know, and I've gone on about this before, but the Tenancy Tribunal is bought and sold by and to Harcourts, and I get to pay $9,000 when they've ruined my life and owe me hundreds of thousands. And if I could hire a good torts lawyer, damages lawyer, I would I would be set for life. But as I have discovered, and I do have to eat a little bit of humble pie to the lefties, justice is for those who least need it. And by justice, I mean the misnamed term for the legal court system. The people who don't need it are the ones who get it. Those of us who need laws to be upheld can't afford to make them be upheld. Yeah, the laws mean nothing. They mean nothing.